Hello everyone, my name is Nkem Ochei and I'm a PhD student at Law School, Robert Gordon University, United Kingdom. The title of my paper presentation is The Impact of Multinational Oil Companies' Levels of Engagement with Human Rights Obligation in Human Rights Litigation in the Niger Delta. The outline of this presentation is as follows. I will first introduce the paper, then I will discuss about the human rights obligations of Shell and the multinational oil companies' level of engagement with their human rights obligation. Also, I will discuss the human rights litigation arising from the Niger Delta. After that, I will discuss my findings and make my concluding remarks. I would like to start by saying that the way multinational oil companies handle issues and compliance varies and can demonstrate the level of engagement with their human rights and environmental obligation. This level of engagement could be inactive, reactive, active, and proactive level of engagement. The lack of appropriate level of engagement is the reason for recurring conflicts and incidents of human rights and environmental violation in the Niger Delta, which in turn has led to numerous transnational human rights litigation. The Niger Delta is an oil-rich region in the southern part of Nigeria and has been a center of international controversy over oil and gas pollution. Also, human rights obligations are policies a company develops or to sign on to indicate what the company intends to address in its human rights and environmental programs. These obligations cover a wide range of variety, including transparency, disclosure of evidence that could be required by the plaintiff, safety and security, prevention of oil spill, cleanup, and also compensation. Now, this paper considers Shell as a case study to illustrate the relevance of human rights and environmental obligation. Shell human rights obligations are contained in several sources, such as its official website, policy and procedure manual, reports, agreements, Shell sustainability report. For example, one of Shell human rights obligations is stated as follows. Shell is committed to respecting human rights as set out in the United Nations Universal Declaration of Human Rights and the International Labour Organization Declaration on Fundamental Principles and Rights at Work. So let's be very clear about the legal importance of the human rights obligation of the multinational oil company, which is usually taken lightly. For example, Shell filed an incorrect information with the United States Security and Exchange Commission, and as a result of that, they had to settle a fraud case with the Security and Exchange Commission in 2004 for overstatement of billions of barrels of proved oil reserve in violation of the Security Exchange Act of 1934. So let us summarize the three transnational human rights litigation, starting with Weaver and Shell. In this litigation, the plaintiff sought to hold Shell liable for complicity in the wrongful arrest, detention, and execution of the 9 environmental activists in 1995 by the Nigerian military. There were two issues for determination. One, the first was whether the court could exercise personal jurisdiction over the defendants, Shell and SPDC, and two, whether the human rights abuses in the litigation fell within the scope of the authority of the federal courts based on the Alien Tort Act. So the Court of Appeal ruled that the U.S. court could exercise both personal jurisdiction and forum non-convenience over the defendants on several grounds, including that Shell was doing business in New York, and the trial would be expensive and inconvenient to the plaintiff if it held if it was held outside the US. So before the eve of the trial, Shell settled out of court on June 8, 2009, settled the sum of $15.5 million. In Bodo and Shell litigation, a group of Nigerian farmers and fishermen filed a lawsuit against Shell and SPDC for two oil spills in Bodo community. There were two main issues for determination: whether the claimants are only entitled to claim compensation in respect of the 2008 spill under the Oil Pipeline Act, and two, whether SPDC could be held liable for the oil spill due to sabotage, or rather faulty maintenance under the Nigerian law. The court ruled that there is no liability for oil spill caused by sabotage under the Nigerian law, but the liability could exist due to neglect in the protection of the oil pipeline. Few months before the trial was set to proceed, on the evidence produced, Shell settled the litigation out of court for the sum of about $55 million. Also in Oguru and Shell litigation, 4 Nigerian farmers and a Dutch NGO filed a claim against Royal Dutch Shell and Expediency for failure to exercise due care to prevent the oil spill and clean up of contaminated sites. The key issues for determinations were: 1. Whether the Dutch court could exercise jurisdiction over the claim against the Nigerian subsidiary, and 2. Whether the oil spill had been caused by faulty maintenance or by sabotage, and 3. Whether the Royal Dutch Shell owes a duty of care to the claimant for harm caused by SPDC. So in most recent decision, in January 2021, the court ruled that Royal Dutch Shell owed a duty of care to the claimant and is liable to pay compensation and clean up due to failure to prevent oil spill. And also Shell was ordered to install leak detection equipment in its pipeline. So let us explain the different multinational oil companies' levels of engagement with their human rights obligation. In the inactive level of engagement, the company approaches the litigation by being defensive and calculating on how to kill the case. In the reactive level of engagement, the company approaches the litigation by being defensive and calculating on how to minimize the risk if they cannot get away with the allegation. Also, in the active level of engagement, the company approaches the litigation to resolve the dispute. In the proactive level of engagement, the company approaches the litigation to resolve the dispute and also contribute to resolving future complaints. So I'll give an example of this. A reactive level is when the company bluntly refuses to disclose evidence, but do so only if it's unavoidable due to legal obligation and also pressure from the government and also investors. And a proactive level of engagement is when the company discloses evidence and also put in place a mechanism to provide evidence in future. Also, an evaluation of the level of engagement against the 3 litigation shows that there is no evidence that Shell proactively shaped and implements its human rights obligation. In the case of Wiwa and Shell litigation, Shell was inactive in its approach because it was defensive and also calculating on how to kill the case. In Bodo and Shell and also Oguru and Shell litigation, Shell was initially inactive at first, but later became reactive in its approach in order to minimize the risk, only if it could not get away with the allegation. For example, Shell only accepted compensation and cleanup of oil spill when evidence emerged in court during litigation. and they were warned of its faulty pipelines, but they failed to take action. So aspects of Shell's inactive and reactive approach to human rights litigation. Shell was inactive and reactive in its approach in several ways, including lack of jurisdiction, non-disclosure of evidence, poor safety and security, prevention of oil spill, delay of litigation, inadequate cleanup, and non-payment of compensation. I would like to discuss a few aspects of Shell's inactive and reactive approach of engaging with their human rights obligation. Shell used several techniques to postpone the litigation initiated against them. In the case of Roma and Shell, Shell filed a motion to dismiss the claim on the ground of lack of jurisdiction. Also, in Oguru and Shell's case, Shell challenged the standing of the individual claimant and also joint claimant, which delayed the case from moving forward. Also, Shell demonstrated a lack of transparency in the oil spill data provided and also refused to disclose crucial evidential documents. In Oguru and Shell litigation, the judge had to intervene by ordering Shell to bring documents to court for analysis by the plaintiff to prove what Shell knew about the case. Also, during Oguru and Shell litigation, the plaintiff lawyers traveled to interview the witnesses about the oil spill data. They found it difficult to interview them due to pressure from the companies and intimidation from the companies, because many of these experts work with the company and they were unwilling to testify against this company. Shell also frequently disputes information related to the cause of the oil spill, the volume of the oil spill, and also area affected by the oil spill. For example, in Bodo and Shaw litigation, Shell only accepted to pay compensation and cleanup of oil spill when evidence emerged during litigation that it was warned of its faulty pipelines but failed to take action, and this approach is reactive. Also, the prevention of oil spill. The multinational oil companies always attribute the cause of oil spill to sabotage because under the Nigerian law, oil spill caused as a result of sabotage or theft, the company won't be held liable and the victims won't be compensated. So let us explain how multinational oil companies with a proactive approach improve human rights and environmental protection. Now, in 2006, the Nigerian government commissioned the United Nations Environmental Programme to conduct an environmental assessment in Ogoniland. Shell was proactive in its involvement as they were part of the independent assessment and also accepted to fund the assessment and provided data as requested. Now, Shell also agreed in advance to accept these findings and also the recommendations of the report. So after the report was concluded, Shell established an independent committee to review its practices on remediation of oil spill and has since commenced a comprehensive cleanup and restoration of contaminated sites in Ogoniland. These findings of the report have been referenced in several human rights litigations in Niger Delta. In this presentation, the impact of multinational oil companies' level of engagement with their human rights obligation during litigation has been discussed. A proactive level of engagement is recommended to improve human rights and environmental damage in the Niger Delta. These are my list of cases and references. Thank you so much, and I'll be happy to answer any questions.